Welcome, class. In this explainer, we're going to tackle one of the most fundamental principles of Indian constitutional law, and that's Article 9. Now, this is a core concept, so you'll definitely want to have your notes ready as we really dig into what it means to be a citizen of India.
So let's kick things off with a foundational question, one that honestly stumps more people than you'd think. Can a person legally hold Indian citizenship and, let's say, American or British citizenship at the exact same time?
The answer, under the Indian Constitution, is an absolutely unequivocal no. And the entire legal basis for that hard and fast rule, it's found in one single, incredibly powerful article, Article 9.
Okay, let's get into the specifics of this foundational rule. It's so important to understand that this isn't just some government policy. It's a mandate written right into the Constitution that really defines India's entire stance on allegiance. So this is the text of the law itself. It's pretty direct, right? It's clear, and it establishes what we lawyers call a bright line rule. Now, notice those key phrases, voluntarily acquired and citizenship of any foreign state. We're going to be dissecting both of those.
Let's break this down. The most critical thing to take away from this is that the loss of citizenship is automatic. There's no paperwork you have to file with India to make it official. The moment you become a foreign citizen, it's done. And this is all rooted in a really fundamental idea. You just can't owe allegiance to two different countries at the same time. For the framers of the Constitution, this was a huge deal, especially in the shadow of partition. It was all about fostering a single, unified national identity.
All right, let's move on to probably the most important word in this entire discussion. It's the one that the Supreme Court has focused on again and again. Seriously, everything hinges on how we interpret the word voluntarily.
So the crucial point here is that this isn't about some accidental or forced situation. The law is really targeting a conscious, deliberate decision. It's about you making a free and unconstrained choice to become a citizen of another country.
And here's where we can see the practical difference. Just look at this table. There's a really clear distinction, right? Formal acts, like going through a naturalization process or taking an oath of allegiance, well, those are definitely seen as voluntary. And that means immediate loss of Indian citizenship. But situations like getting citizenship automatically by birth or through marriage, that's where things get a bit more nuanced, and the courts have to look at them on a case-by-case basis. Now, this next part is where a lot of students get tripped up. So let's take a minute to clarify two very common terms that are so often mistaken for dual citizenship. You'll want to pay close attention to this section.
Okay, pay close attention because this distinction is absolutely essential for your exams. An NRI, a non-resident Indian, is simple. They are a full Indian citizen, they have an Indian passport, they just happen to live somewhere else. An OCI, on the other hand, an overseas citizen of India, well, that person is not a citizen at all. You can think of it like a special lifelong visa status for people of Indian origin who actually hold foreign citizenship.
I'm going to say this again because it is that important. And it's a classic exam question. Holding an overseas citizen of India card is not dual citizenship. It's a status, sure. It provides certain rights, but it absolutely does not violate the single citizenship rule of Article 9. So theory is one thing, but how does all this actually hold up when it gets tested in the real world? Let's turn to some landmark Supreme Court cases that have given us really clear guidance. Our first case, Shah Muhammad, is the one you absolutely have to cite when you're discussing what voluntary means in the context of a formal application. I mean, it provides a super clear, definitive answer.
The facts here are pretty straightforward. A man acquired Pakistani citizenship, and then later on, he tried to argue that it wasn't a truly voluntary act so that he could claim property rights back in India. So the big question for the court was this: does formally applying for foreign citizenship count as a voluntary act under Article 9?
The Supreme Court's decision was absolute. They said the act of applying is the voluntary choice. The very moment he obtained that Pakistani citizenship, his Indian citizenship was automatically terminated. No room for debate, end of story. Okay, this next case tests the limits of that word voluntary when some really difficult external circumstances are involved. I mean, what happens when someone feels pressured into taking another country's citizenship? Here, the argument was a lot more sympathetic, The person claimed they were essentially forced by the chaotic circumstances of the partition to acquire Pakistani citizenship. The legal question became, could that kind of external pressure or duress actually negate the voluntary nature of the act? The court acknowledged the harsh realities of the time, for sure, but ultimately they held that voluntary means a deliberate choice. So even if the reasons for making that choice were incredibly difficult, the act of accepting foreign citizenship was still a conscious one, and so the claim failed.
Finally, let's look at one last case that clears up a really crucial procedural point. Do you need to formally tell India that you've become a citizen of another country for your Indian citizenship to end?
The issue here was simple, but really important. Is the termination of Indian citizenship an automatic process, or does it require a whole separate step, like, say, filing a renunciation form with the Indian government?
And the court confirmed the process is entirely automatic. The moment you voluntarily acquire foreign citizenship is the exact moment your Indian citizenship ceases to exist by operation of law. No other action is required from you. All right, class, let's quickly summarize the absolute must-know points from our discussion today. If a question on Article 9 comes up on an exam, these are the pillars of your answer.
Okay, this is your exam-ready checklist. If you can master these 4 points, you will have a strong command of this topic. First, define voluntarily. Second, state the core rule against dual citizenship. Third, clearly differentiate OCI from NRI. And finally, cite the Shah Muhammad case as your key authority. That right there is a winning formula.
So as we conclude, I'll just leave you with this question to ponder. We've talked a lot about what the law is, but it's also important to think about what it should be. In an increasingly integrated world, does a strict rule of single allegiance still make sense, or is it a principle that maybe needs to be revisited? Something to think on as you review your notes.